You meant to kill her.
I definitely meant to kill her.
It wasn't an accident.
No, not at all. If I had a chance to do it again, I would.
The defendant's actions in this case killed her own child.
I am not okay.
And he shoots him. He shoots twice, strikes him once, and as a result.
The investigation into the tragic murder of 72-year-old Hussein Murray in Rochester Hills, Michigan, is still ongoing. The two suspects, Carlos Hernandez and Joshua Zuazo, both from Dearborn, Michigan, had been accused of posing as DTE energy workers to gain entry to the Murray home, where the crime unfolded. It all began the evening before the murder. The suspects approached the house pretending to be utility workers, but their plans were thwarted when the Murray family spotted them on a Ring camera and refused to let them in. Undeterred, the men returned the following day, again using the same false claim to enter. This time, they succeeded. Tragically, Hussein Murray was found dead in the basement, and his wife, also 72 years old, was discovered upstairs, bound with duct tape. Law enforcement quickly sprang into action. Within 24 hours, Carlos Hernandez was captured in Shreveport, Louisiana. He waived extradition and was transported back to Michigan to face justice. Meanwhile, Joshua Zuazo was arrested in Plymouth Township, Michigan. Investigators uncovered that Zuazo had an extensive criminal history, spanning more than 25 years and involving violent offenses, robberies, and firearm-related crimes.
We do show that he has extensive criminal history that dates back 2.5 decades, which includes a lengthy history of violence.
In this matter, bond will be denied pursuant to 6.106B and F. It is obvious that these charges are very serious. This court has a concern about the public safety, and this court does have concern about a flight risk.
Now in custody, both men appeared in court, where Zuazo was denied bond due to the seriousness of the allegations and concerns for public safety. Legal proceedings are underway, and if convicted, the suspects faced life imprisonment without parole for the murder charge, along with up to 15 years for each count of unlawful imprisonment. As detectives continued to investigate the case, they worked to uncover additional details and identify any other individuals who might have been involved. Pamela Cabrera, a mother from Jacksonville, was set to be sentenced for the death of her daughter, Vanity, but chaos in the courtroom caused her removal before the proceedings could be completed. The sentencing, which was meant to bring closure to a heartbreaking case, quickly turned disruptive as Cabrera repeatedly interrupted, despite warnings from the judge.
Cabrera, you have to whisper and not talk when the other side is talking.
Less than 30 minutes in, she was escorted out, and the session paused briefly. When it resumed, Cabrera participated remotely via Zoom from another room.
There's a kid in the car. It's a small kid.
The tragedy unfolded in 2022, when Cabrera, battling mental health issues, kidnapped her daughter and led police on a dangerous high-speed chase. The pursuit ended in disaster, as Cabrera crashed into a retention pond. She survived, but her daughter, Vanity, tragically lost her life. Earlier this year, Cabrera pleaded guilty to aggravated manslaughter of a child and aggravated fleeing or attempting to elude causing death, leaving her facing a possible sentence of 10 to 30 years. During the hearing, officers from the Jacksonville Sheriff's Office testified about Cabrera's actions on the night of the crash. Body camera footage revealed her combative behavior and resisting arrest. Her sister, Whitney Baez, also took the stand, explaining that Vanity had been in her care due to Cabrera's erratic behavior and ongoing mental health struggles. Baez described a woman struggling with her own demons, but still deeply connected to her daughter. The defense argued that Cabrera's actions were the result of a mental health breakdown and the effects of heavy medication, pointing to her irrational behavior in court as further proof of her struggles. Prosecutors, however, maintained that Cabrera knew what she was doing, emphasizing the danger she posed not only to Vanity, but also to others on the road and the officers trying to help.
It really does underscore the nature of the mental illness that Pamela Cabrera suffered from and still suffers from. You can see by her behavior in court that she's acting irrationally.
The defendant's actions in this case killed her own child, endangered people on the roadways, endangered the lives of officers who were attempting to rescue her and the child.
The The prosecution pushed for a 30-year sentence, calling her actions reckless and devastating, while the defense requested a 10-year sentence with continued mental health treatment. However, the judge imposed the maximum sentence of 30 years, emphasizing the severity of the crime. The murder of 29-year-old Allison Appling France remains one of the most harrowing crimes Cleveland has witnessed. A devoted mother, Allison was gunned down in front of her daughters. Jamar Skanes, 50, and Alantez Beasley, 35, had been hired to kill Allison.
You sold your lives.
The two men stalked her relentlessly, first watching her at her home, then following her to a store. When Allison returned home, Beasley ambushed her and fired shots, killing her on the spot.
It's a nightmare what my daughter experienced.
In the aftermath, Allison's mother stepped in to care for her granddaughters, now left to grapple with the trauma of witnessing their mother's death.
These little girls cannot live in fear that someday you're free in this world.
During the trial, her family described the pain and fear that consumed them, pleading with the court to ensure the men responsible would never walk free again.
Heartless, evil, weak men, them from us, please, from society.
Authorities are still searching for a third suspect, 44-year-old Clarence Bennett, who remains at large. In court, the behavior of the two convicted men only deepened the outrage. Beasley, the shooter, declined to speak, offering no explanation or remorse for his actions.
I am terrified of what about that because I am not a killer.
Skanes, on the other hand, apologized but claimed he had no role in the killing, insisting he was merely in the wrong place at the wrong time, looking for a ride to work.
I had no idea all this was going on. I was in the wrong place at the wrong time.
The judge, Brendan Sheehan, dismissed his defense entirely, pointing to overwhelming evidence that Skanes had been involved throughout the crime.
You stood here and tried to act like you had no idea what was going on. Is disgusting.
In the end, the court delivered the harshest possible punishment. Skanes and Beasley were each sentenced to life in prison without the possibility of parole. The judge emphasized that the sentence was not only for justice, but to ensure the safety of society from individuals who had committed such a cold-blooded and calculated act. A Waukesha County jury found Kevin Seymour guilty of felony murder in the tragic death of Joshua Davies, delivering justice more than a year after the incident. The events leading to Davies' death unfolded on June 17, 2023, Hobby's Lake Country Wine Bar in Heartland, Wisconsin. Joshua Davies, 39, was enjoying a night out with his wife when an encounter with 65-year-old Kevin Seymour took a deadly turn. Unprovoked, Seymour began criticizing Davies' tattoos, declaring them sinful and accusing him of going to hell. Witnesses reported Seymour's aggressive and taunting behavior, which escalated as the night went on. Despite efforts by other patrons to defuse the situation, Seymour followed Davies outside the bar. Surveillance footage captured the altercation, and prosecutors argued that Seymour was looking for a fight.
Kevin Seymour's looking for a fight.
The defense claimed self-defense, alleging that Davies had approached Seymour with a metal stool.
So Davies had something in his hand.
However, witness testimony and surveillance evidence contradicted this account. Prosecutors stated that Kevin Seymour struck Josh Davies, causing him to fall and sustain severe head injuries. These injuries eventually led to Davies passing nearly a month later.
In order for Josh to have the injuries that he did.
Throughout the trial, Seymour did not testify in his own defense. However, a recorded police interview became pivotal in the case. In the video, Seymour admitted, "I pushed him," a statement that proved damning for the defense.
Yes, I pushed him.
The jury requested to review this recording during deliberations, reinforcing their decision to convict him. Following the guilty verdict, Davies' family expressed a mix of relief and heartbreak. They described Joshua as a peaceful, loving man who avoided confrontation. His parents, holding back tears, shared a message of kindness and understanding for the community, hoping to prevent similar tragedies.
I got his tattoo and I got his armbands on, and you know what? We're very happy with the way it turned out.
Never.
In September 2024, Seymour was sentenced to 7 years in prison, followed by 5 years of extended supervision. While the sentence brought closure to the trial, Davies' family voiced disappointment, believing it to be insufficient given the gravity of the crime. a tragic shooting shattered the peace of a student's flag football game in Milwaukee, leaving a community grieving and demanding justice. On October 12th, 47-year-old Raisin Barnes attended the game at South Stadium to support a friend's son. What began as a simple outing turned into a devastating event when Barnes was killed. The day took a deadly turn when a fight erupted between two men at the game. Gavino Avalos Morales, 30, who accompanied one of the men involved, drew a firearm to intervene.
Intentionally brought a firearm to a fourth grade football game.
Surveillance footage captured the chilling moment. Barnes, uninvolved in the altercation, was walking back to his car to retrieve a water bottle when Morales confronted him. Barnes raised his hands, signaling he was not part of the dispute, but Morales fired, fatally striking Barnes.
Who has his hands up as if to suggest, hey, I'm not involved in this, and he shoots him. He shoots twice, strikes him once, and as a result, we have a homicide in the middle of a fourth grade football game.
Families and students who came to enjoy the game witnessed the horrifying scene, which turned the stadium into a crime scene. Barnes's family, devastated by the loss, expressed their outrage. His brother called the act unbelievable and tragic, describing Morales as a monster.
The individual that did this is a monster to me, and is a monster to my family, and it should be a monster to the Milwaukee community.
Authorities later linked the firearm used by Morales to another shooting incident just blocks away, but no additional charges have been filed in that case. In response to this tragedy, Milwaukee Public Schools announced heightened security measures at youth games, including weapon screenings with metal-detecting wands at stadium entrances to ensure the safety of attendees. Morales was arrested and charged with first-degree reckless homicide. During his court appearance, his bail was set at $250,000. As of now, Morales remains in custody, awaiting trial. A preliminary hearing has been scheduled to determine if sufficient evidence exists to proceed to trial. If convicted, Morales faces severe consequences, with the first-degree reckless homicide charge alone carrying a potential sentence of up to 60 years in prison. Ahmaud Williams was just 15 years old in 1998 when a tragic event changed two families forever. During an argument over a drug deal in a Grand Rapids liquor store parking lot, Williams shot and killed a boy, Derek Pimpleton. The crime, described as cold-blooded by prosecutors, left a lasting scar on Pimpleton's family and resulted in Williams being sentenced to life in prison without the possibility of parole. For nearly 2 decades, Williams lived with the belief that he would never see freedom again. But a U.S. Supreme Court ruling opened the door for juvenile lifers like him to have their cases reviewed. In court, Williams expressed deep remorse, telling those present,
"It's not a day that doesn't go by that I'm not in regret. And I will always have remorse for the rest of my life for what I've done."
The hearing was emotional, especially for the victim's family. Derek's sister, Danica Cooper, spoke through tears about how the murder changed their lives.
Just didn't grow up the same. He took somebody else's life, and you know, I do feel like one day he should get out, but I don't feel like it should be any time.
Ultimately, the court decided to reduce Williams' sentence, citing letters of support from the original trial judge and Williams' probation officer. Judge Trusock resentenced him to 25 to 60 years in prison. This makes Williams eligible for parole in less than 9 years. While his family and friends celebrated this second chance, the victim's family remained conflicted, torn between the pursuit of justice and the hope for healing. In April 2012, the Hustle Mart in Farmville, North Carolina, became the site of a heartbreaking tragedy. 3 employees, Mokbel Sam Mohammed Al-Mujanahi, 24-year-old Gaber Alawi, and 26-year-old Nabil Nasser Saeed Al-Moganahi, were murdered during a robbery. The devastating loss left their families and the community in mourning, sparking a long legal journey to bring those responsible to justice. The events of that day were chilling. The perpetrators, including Willie Whitehead, Antoine Anthony, Xavier Shambles, and Raekwon Blount, entered the store intending to rob it, but ended up committing murder. corpse. Years later, Willie Whitehead, one of the key suspects, faced trial. After a few hours of deliberation, the jury found him guilty on 3 counts of first-degree murder and 1 count of armed robbery. During his sentencing, Whitehead showed little remorse, smirking and making hand gestures as his fate was read aloud. In court, the prosecution painted a clear picture of Whitehead's involvement, emphasizing the brutality of the crime.
Thankful to the jury and grateful for the citizens of this county for being patient and wading through this evidence and applying the laws that needs to be applied. And they've let us know how thankful they are to our office and to the Sheriff's Department for all the work that's been put in this case from 4 years ago.
Meanwhile, his defense team expressed disappointment with the verdict, vowing to appeal.
Shock, worry, concern. He'll not be eligible for parole. We've given notice of appeal. The fight is not over, but this battle in this courtroom has come to a conclusion today.
Adding to the emotional weight of the trial, Whitehead's father addressed the victims' families, apologizing for their loss.
I'm so sorry, and I want y'all to know that I'm sorry from my heart. I wasn't there when it happened. If it would, I would have stopped it. I'm quite sure that everybody else would, but I'm sorry. And I want y'all to take into consideration that my son haven't killed nobody. But I'm sorry for your loss. I really am.
In September 2016, Willie Whitehead was sentenced to 3 consecutive life terms without the possibility of parole. His sentencing came after that of Antoine Anthony, who had been convicted earlier in the same case. As the mastermind and primary assailant, Anthony faced multiple charges, including first-degree murder and armed robbery, and was sentenced to death in March 2016 for his central role in the murders. Raekwon Blount, who was just 14 years old at the time of the crime, accepted a plea deal in November 2016. He pleaded guilty to 3 counts of second-degree murder and 1 count of robbery with a dangerous weapon, receiving a sentence of 9 to 12 years in prison. That same month, Xavier Shamble also entered a plea agreement. He admitted guilt to 3 counts of second-degree murder and 1 count of armed robbery and was sentenced to a prison term of 13 to 18 years. The family of Harris County Sheriff Sergeant Ramon Gutierrez shared their heartbreak in court as they delivered powerful victim impact statements, recounting the devastating loss of a devoted husband, father, and law enforcement officer. Their words came just 1 day after the conviction of 43-year-old Lavia Spry, who was found guilty of intoxication manslaughter for the hit-and-run crash that took Gutierrez's life.
Driving drunk is not an accident, and somebody when you're driving drunk is a predictable consequence. Therefore, it could have been prevented.
In January 2022, Sergeant Gutierrez was working an off-duty job directing traffic for an oversized load along the Beltway. A highly intoxicated Spry ignored emergency vehicles, drove around them, and struck Gutierrez before fleeing the scene. The 45-year-old sergeant, who had spent 2 decades in law enforcement specializing in vehicular crimes, tragically lost his life. At the time, he was taking on extra work to help pay for his daughter's upcoming wedding. Gutierrez's family described him as an incredible man who embodied everything expected of a police officer and father. His son, Alfredo, shared.
My dad spent his entire life dedicated to keeping drunk drivers off the street, to keeping families safe. My dad was an amazing man. He was everything that we ask police officers to be. He was everything that we ask a father to be.
Returning to court in a jail uniform, Spry apologized to the family, expressing deep remorse and describing the crash as an accident. She claimed to see Gutierrez in her dreams and said she believed he would forgive her. Her attorney emphasized that Spry wanted to personally address the family to convey her sorrow. The jury took less than 15 minutes to convict Spry of intoxication manslaughter. She was sentenced to 43 years in prison for her actions, a punishment reflecting the severity of her crime. Spry, who had given birth to her own daughter just a month before the crash, will likely remain incarcerated until her mid-80s if she serves the full sentence. The murder trial of Nima Momeni, accused of killing Cash App founder Bob Lee, unfolded with gripping details and intense courtroom moments. On April 4th, 2023, Lee was in San Francisco. Prosecutors argued that the killing stemmed from a personal conflict involving Momini's sister, Khazar Eliasnia. They alleged that hours before the attack, Momini confronted Lee in an aggressive phone call, accusing him of providing drugs to his sister and acting as an overprotective tough guy. Security footage showed Momini and Lee leaving the Millennium Tower together in Momini's white BMW. They drove a short distance to Main Street near the Bay Bridge, where an argument broke out. The footage reportedly captured Momini making an aggressive move toward Lee. Shortly afterward, Lee was found stabbed a few blocks away, and a kitchen knife believed to be the murder weapon was discovered nearby. During the trial, testimonies from Lee's family and friends shed light on his relationships and the events leading up to his death. Momini also took the stand, sparring with prosecutors as the defense argued he acted in self-defense. The prosecution, however, maintained that the stabbing was premeditated and motivated by anger. After weeks of testimony, the jury began deliberating in early December 2024. By mid-December, they are yet to reach a verdict, with discussions scheduled to continue. If convicted, Momini will face a sentence ranging from 26 years to life in prison. Mitchell Blair, a Detroit mother infamous for one of the most disturbing cases in recent memory, faced additional prison time after assaulting a prison employee. Already serving 2 life sentences for the murder of her daughter and son, Blair once again demonstrated her unrepentant nature during her court appearance. Blair's crimes shocked the nation. She admitted to killing her son and daughter and hiding their remains for years. Investigators uncovered the horrifying truth when the girl and boy's remains were discovered during an eviction. In court, Blair showed no remorse, openly confessing that she meant to kill her and would do it again if given the chance.
You meant to kill her?
I definitely meant to kill her.
Okay. It wasn't an accident?
No, not at all. If I had a chance to do it again, I would.
Her most recent charges stemmed from an assault behind bars. During the hearing, Blair shifted blame onto prison staff, claiming they provoked her actions.
Anything that you'd like to tell me before I impose sentence, Ms. Blair?
Just the same thing I've been saying. If the officers wouldn't provoke me, it wouldn't happen.
Her defiance escalated into an outburst in court, though she eventually regained composure before the judge delivered her sentence.
You're in a difficult situation. They're in difficult positions, and you just have to control your anger in the future.
The court added 38 months to 5 years to Blair's existing life sentences for the assault. This additional punishment reflected not only the severity of her actions, but also her inability to manage her behavior, even in a controlled environment. Lamora Williams, a mother at the center of one of Atlanta's most harrowing cases, was convicted for the brutal murders of her 2 young sons. The tragic events unfolded in October 2017 when Williams called 911, claiming she had returned home to find her sons, Jacarter Penn and Keontae Penn, dead. She initially blamed a caregiver for their deaths, but investigators quickly uncovered a far more horrifying truth. Authorities determined that the boys' deaths were caused by actions taken within the home. Before contacting law enforcement, Williams made a video call to the boys' father, Jamil Penn, showing him the aftermath. The discovery of the boys remains sent shockwaves through the community. Throughout her trial, Williams pleaded not guilty, maintaining her innocence. Her defense pointed to her history of mental health struggles and the overwhelming pressures of single parenthood as possible factors, suggesting she may have snapped.
When I saw that mugshot of her, I knew that was not my little sister.
However, prosecutors presented damning evidence, including the timeline of events and witness accounts, painting a clear picture of her actions.
She came from the jailhouse to let them know to put her inside watch because she's gonna kill herself.
The jury found Williams guilty on all 14 counts, including murder, felony murder, cruelty to children, and making false statements. In November 2024, she was sentenced to life in prison without the possibility of parole, along with an additional 35 years. In December 2023, Trevor Scheel, a 24-year-old man from Wisconsin, faced sentencing for a tragic hit and run incident that took the life of 73-year-old Barbara Helms. The events, marked by poor decisions and devastating outcomes, unfolded in 2022 and left a lasting impact on all involved. On the day of the crash, Scheel spent several hours at a casino, consuming a significant amount of alcohol. Despite knowing the risks, he drank 4 double shots, raising his blood alcohol concentration. BAC to 0.206, well above the legal limit. Afterward, he chose to drive, disregarding the clear dangers of his impaired state.
Because you went to the casino by yourself. You drank there by yourself. Nobody influenced you to do any of that. And frankly, the decision to drink 4 drinks, which you knew were doubles because you ordered them as doubles, was pretty irresponsible. And you were there for just over 2 hours. So it's a lot of alcohol, regardless of whether they were poured heavy or it was more than 8 shots, it was still, at a minimum, you knew 8 shots. And one of the things that just didn't make sense about any of that was your whole description about how you were going to spend the day with your girlfriend, because you guys had just celebrated your 4th anniversary, you went to Door County, it wasn't quite as fun as you had hoped, some places were closed, et cetera, and you're going to spend this day together, and yet you left, went to the casino, drank a lot, and then got in a car and drove, frankly, like a reckless maniac, if you really look at it.
As Shield drove at nearly 60 miles per hour in a 35 miles per hour zone, he struck Barbara Helms, who was crossing the street. The impact was catastrophic. Witnesses described how Helms was thrown onto the hood of his car and into the windshield before landing several feet away. Her belongings, including her glasses, were scattered up to 90 feet from the crash site, evidence of the immense force of the collision. Shield made no attempt to stop or help. Instead, he fled, leaving Helms fatally injured on the road.
Talks about the fact that you're going about 58 miles an hour in a 35 mile an hour zone when you hit Miss Helms. And your attorney is right. If you had not been under the influence, you should have seen her. And you should have been able to stop. Regardless of whether she stepped off in an uncontrolled area or whatever had been happening. But this poor 73-year-old woman was just brutally. And, you know, the description, I saw all of the other attachments, talks about blunt force trauma. She basically flew up onto your hood and windshield and was disturbing to read that people saw this. So some of the other people, I know you mentioned first responders, but the people who saw this, the witnesses, that had to have a huge impact on them and their lives as well, because people don't expect to see that kind of a horrible impact and a woman go flying. One witness said she flew 10 feet in the air before she hit the ground. One of her shoes flew off. Her glasses were located some 90 feet away. So it was quite an impact. When people talked about seeing you driving at a high rate of speed, passing you, one person said you passed him, were traveling really fast, and then he saw you hit the victim. And that you had never attempted to brake, slow down, or stop. And then you just left. You made no effort to stop. No effort at all to see if this person, who you didn't know at that point, I don't even think you knew if it was a man or a woman, you just knew you hit somebody.
Witnesses quickly reported the incident, and investigators pieced together the events through eyewitness accounts, physical evidence, and Shield's own admission to heavy drinking. Helms's death left her family heartbroken, as she had been a beloved member of her community. At his sentencing, Shield took responsibility for his actions, apologizing to Helms' family and expressing deep regret. He stated his intention to use his experience to warn others about the dangers of drunk driving.
I just want to express how sorry I am. I'm sorry to the victim's family and friends who now have a loved one they'll never see again. To the other drivers on the road around me whose lives I put in danger. To the police officers and first responders on duty that day. To my parents whose only son is now incarcerated. I wasn't myself that day, and I'm sorry to everyone that was affected by what I did. I can't express enough how much I regret my actions. I take full responsibility for my actions and don't blame anyone but myself. Even though I made negligent decisions that day, I want people to know I truly don't wish harm on anyone and my intentions are good. I can't control what I already did in the past. What I can control is what I do going forward and the decisions I make in the future. My goals in the future are to one day have a family of my own, learn a trade, be a good neighbor, somebody that benefits the community. Most of all, to regain the trust my family and friends had in me before this tragedy. One thing is for sure, and that is that I won't get there by drinking or gambling. Also, I believe I can use what happened here to educate others on the dangers of drunk driving, not only to yourself, but to the innocent lives around you as well, potentially saving a life or preventing someone else from being in my shoes. I promise never to put anyone else's life in danger again. I can't even imagine how I'd feel if someone came up to me and told me that my mom or dad was just hit and killed by a drunk driver. I'd be absolutely devastated. That's not something I'd wish on anyone. And I just want to reiterate how deeply sorry I am for taking a life, to the husband and anyone else whose life is forever impacted because of it.
While the court acknowledged his remorse and clean record, it focused on the seriousness of his actions and their irreversible consequences. The court emphasized that Shields' decisions not only caused Barbara Helms' death, but also deeply affected her family and the witnesses who saw the crash.
That you left the scene afterwards and made no effort to see if Miss Helms was okay. And although there's a lot of things that can be said positively about you, that is very concerning. And sometimes there does, your attorney acknowledged this as well, need to be a punishment component of a sentence. So I'm going to sentence you on count 1, homicide by intoxicated use of a vehicle, to 13 years in the Wisconsin State Prison System, to be bifurcated as 6.5 years of initial confinement and 6.5 years of extended supervision. I'm going to impose the same sentence on count 2, hit and run resulting in death, 13 years divided as 6.5 of initial confinement and 6.5 years of extended supervision. Those sentences will run concurrent to each other. I think that those sentences, although they probably can never be significant enough to a victim when they've lost their loved one, I think it does take into consideration those factors the court has to consider. I think that the lesser sentence than what the state is asking for is warranted because of the positive things about your character. You're a very young man who has every ability to rehabilitate and make a difference in this world going forward. But I think it needs to be a little longer than the 5 years that the legislature imposed as a mandatory minimum, because it is the minimum. And I think this, because of the factors I've already articulated, I think it warrants more than that. As conditions of your extended supervision, I am going to order that you undergo a COMPASS evaluation and follow through with any treatment recommendations that are made as a result of that evaluation. You're to undergo an AODA assessment and follow through with treatment recommendations. You're to maintain absolute sobriety. You're not to be in possession of any alcohol. You're to obtain and maintain full-time employment. You're ordered to not drive unless you have a valid driver's license and an appropriate ignition interlock device if you're under the conditions of that, because I am ordering you with regard to count 1 that you have an ignition interlock device installed in your vehicle for a period of 5 years. Additionally, as it relates to count 1, your driving privileges will be revoked for a period of 5 years.
The judge sentenced Shield to 13 years in prison, separated into 6.5 years of initial confinement and 6.5 years of extended supervision for homicide by intoxicated use of a vehicle. For the charge of hit and run resulting in death, he received a concurrent sentence of 13 years. As part of his sentence, his driver's license was revoked for 5 years, and he was ordered to pay fines totaling over $3,500, including court costs and a blood draw fee. The conditions of his extended supervision include absolute sobriety, participation in alcohol and drug treatment, and engagement in educational programs to raise awareness about the consequences of impaired driving. The tragic events of February 11, 2009 forever changed the lives of many in Jackson, Mississippi. Karen Irby, driving her Mercedes-Benz with her then-husband Stuart Irby as a passenger, crossed the center line of Old Canton Road and collided head-on with a pickup truck. The crash killed 2 respected physicians, Dr. Daniel Pogue and Dr. Lisa Dedausis, who were in the other vehicle. Both doctors died instantly, while Karen and Stuart Irby suffered serious injuries. Investigations revealed that Karen had a blood alcohol content of 0.09 above the legal limit of 0.08 and was driving at over 100 miles per hour at the time of the accident.
She can read whatever, as long as she gives me, you must, Ms. Irby, give me facts sufficient for me to accept your guilty plea. And under the circumstances, I believe that the charge that you're pleading to is culpable negligence manslaughter, which requires, in this situation, you to indicate to me that you had the alcohol, and that as a result of that, 2 people were killed.
Yes, ma'am.
So that's the only part of the statement that I'd asked you to say to the court.
I did have 2 glasses of wine and was driving excessive above the speed limit and drove into an oncoming lane and had an accident, and 2 people died as a result of this.
And in terms of that, you do not challenge the blood tests and the results that have been submitted by the state of Mississippi in terms of the amounts? And
not at this point.
And at this point, you agree that you are above the legal limits?
Yes, ma'am.
Counsel, the defendant has stated and admitted her guilt in this case. She has stated facts sufficient for this court to accept her plea of guilty. Is there a recommendation for sentencing coming from the state?
No, Your Honor, this would be an open plea. There is no recommendation as far as sentencing from the state.
I would have preferred an offer of a sentence or recommendation coming from the state, Ms. Irby, but the state is not providing the courts a recommendation for sentencing. As such, then the court.
In May 2009, Karen Irby was indicted on 2 counts of depraved heart murder and 1 count of aggravated assault. Faced with these charges, she later pleaded guilty to 2 counts of culpable negligence manslaughter in March 2010. This plea agreement led to the dismissal of the depraved heart murder charges. Karen was sentenced to 18 years in prison for her role in the fatal crash.
When I first saw you in the omnibus hearing, you were facing life in prison. You and your good counsel worked with the district attorney and struck a plea that did not even allow for aggravated assault or aggravated DUI, which would have been 25 years for each person, and I could have run it consecutive and you would have been looking at 50 years. If what they say is true, the district attorney's office had the good sense to drop Stuart Irby as a victim. But you're not facing that, and that's lenient. What you are facing is 20 years, and by law, I can't run them consecutive. I must run them concurrent. The court thus sentenced you in honor of the life of Lisa DeDucey to a term of 20 years in the custody of the Mississippi Department of in honor of the life of Mark Pope. The court sentences you to 20 years in the custody of the Mississippi Department of Correction. Because this court does believe that Stuart Irby had a hand in that wheel that night, the court reduces the sentences of 20 years by 2 years and run each of those concurrently. You will thus spend 18 years in the custody of the Mississippi Department of Correction for the life of Dr. Pope and 18 years in the custody of Lisa DeDucey, MD.
In January 2012, Karen Irby was granted clemency by then-Governor Haley Barbour. Citing the traumatic brain injury she sustained during the crash, her sentence was reduced to house arrest for 3 years. By early 2015, she had completed her house arrest and transitioned to unsupervised custody, effectively ending her time under state supervision. The crash also sparked civil lawsuits. The families of Dr. Pogue and Dr. DeDucey filed wrongful death suits against Karen and Stuart Irby. Irby, seeking $60 million in damages. Reports suggested that Karen reached a settlement with the families, which included her agreement to cooperate as a witness in any potential litigation against Stuart Irby. The terms of this settlement likely addressed Karen's financial obligations as well. The personal aftermath of the crash was equally devastating. Stuart Irby, who suffered a traumatic brain injury, struggled to adapt to life after the accident. In 2011, he filed for divorce from Karen, citing irreconcilable differences. Tragically, in January 2012, Stuart took his own life, adding another layer of heartbreak to an already devastating situation. In 2019, Karen Irby, now known as Karen Collins, sought a pardon for her role in the crash. However, Governor Phil Bryant did not issue pardons during his term, leaving her request unresolved. Madeline Kingsbury, a 26-year-old mother of two from Winona, Minnesota, vanished on March 31st, 2023. Earlier that day, she and her former partner, Adam Fravel, had dropped off their daughter and son at daycare. Kingsbury never returned to pick them up, sparking immediate concern among her family and friends. The disappearance triggered an extensive 69-day search involving thousands of volunteers, law enforcement agencies, and community members. Fravel, who was not living with Kingsbury at the time, became a person of interest early in the investigation. Despite denying any involvement, evidence began to suggest otherwise. Investigators discovered that Kingsbury had been planning to leave Fravel, citing his abusive behavior as a significant concern. Witnesses later testified about Fravel's history of domestic violence and threats against Kingsbury, including a chilling comment comparing her potential fate to that of Gabby Petito, who also died in a similar way. On June 7, 2023, after weeks of searching, Kingsbury's body was discovered in a culvert near Fravel's parents' property in Fillmore County. The medical examiner determined that she had died from homicidal violence, most likely asphyxiation. This discovery ended the search, but deepened the grief for Kingsbury's loved ones, who had clung to hope for her safe return.
With a few examples, you can perhaps put yourself in my place. 69 days spent searching desperately for her. Nights staring out into the darkness, wondering where she was. Wondering if she was alive or dead, and wondering if we would ever find her. Then informing my family that our beloved daughter and sister was found dead. Learning that her had been found wrapped in a sheet, stuffed in a culvert, covered with brush at the end of a dead-end road. Finally located because the sheriff's deputy was alerted by an unusually large gathering of flies. Authoring my youngest child's obituary. Telling my grandchildren they'd never see their mommy again because their father had hurt her so badly that she died.
In November 2024, after months of legal proceedings, Fravel was tried for Kingsbury's murder. Prosecutors presented evidence of his premeditated actions, including his efforts to cover up the crime. Witness testimony highlighted the toxic and abusive nature of their relationship, with friends and family recalling the control and fear Fravel exerted over Kingsbury.
The facts laid bare that she was attacked and killed by a coward twice her size, someone who she had once loved. She had made the audacious decision that she didn't deserve to be used or abused by him anymore. With that decision, her future was now looking bright, whereas life with him had been bleak and miserable. Unfortunately, she fatally misjudged him. When he realized that he couldn't control or manipulate her any longer, he decided to kill her. He thought, incredibly, he'd run home to his parents' house and apparently just waited out. He thought no one would care about what happened to Madeline. No one would be the wiser. She'd just fade into memory while he'd get away with murder.
I was not the one to ultimately tell the children that their mother died. My father and stepmother took that burden, but I've certainly been there for the questions and the wonderings of a 3- and 6-year-old, both about their mother and their father. I've been there to hear my 6-year-old niece say that mommy was too young to die.
At the sentencing hearing, Kingsbury's sister, Megan Hancock, delivered an emotional victim impact statement. She recounted the harrowing 69 days the family spent searching for Kingsbury and the lasting trauma caused by her loss. Kingsbury's daughter and son, now in the care of her parents, face life without their mother.
Mr. Fravel, the jury has found you guilty of 2 counts of first-degree murder and 2 counts of second-degree murder. Under Minnesota statutes, a defendant may not be convicted of multiple counts of murder for the same offense, arising from the same acts, and involving the same victim. Therefore, you will be sentenced solely for the conviction of murder in the first degree premeditation, with the remaining charges being vacated as lesser included offenses. The sentencing worksheet is correct. This is a severity level 12 offense. Under Minnesota statute, the law mandates a sentence of life imprisonment without the possibility of release for first-degree murder premeditation. Therefore, Mr. Fravel, it is the judgment of this court that you be committed to the custody of the Commissioner of Corrections and sentenced to life imprisonment without the possibility of release. The sentence reflects the severity of your actions and serves as a clear statement that such violence will not be tolerated in this community. It is my hope that today's proceedings will bring a measure of closure for those impacted.
A jury found Adam Fravel guilty of first-degree premeditated murder and other related charges. On December 23, 2024, Fravel was sentenced to life in prison without the possibility of parole. A woman appeared in court seeking help with overdue rent, explaining that her family was in a difficult financial situation. She and her husband had fallen behind on payments, and their balance exceeded $3,000. This amount made them ineligible for assistance from agencies they contacted. A primary organization approach declined their application because of the high balance and did not offer alternative solutions, such as partial aid or a payment plan. Other well-known organizations, Salso, couldn't help, as their assistance caps were far below the amount owed. Despite submitting applications to 2 additional programs, these were also denied, leaving the family without options.
You take your hand.
I apologize. Sorry.
It's all right.
We called Hawk and they basically said that our balance was too high for them to assist us. So I've been calling other places. They've also told me the same thing, but I recently just talked to my manager of Sycamore Meadows, and she said that we could call together to try to see why they're saying that.
Hold on a minute. Where's Amy?
In the breakout room.
I'll adjourn it out. They told you your balance was too high and they wouldn't assist you?
Yes, sir. Yes, sir. My husband called and I called. And first I was trying to find other people to try to help me bring it down, but they said they couldn't help me either, so I was stuck.
Hold on. So they didn't say, we can help you up to whatever amount, 3,000. You just have to pay this other amount.
No,
they didn't say that?
They didn't tell me that, sir. They told me that because my balance was over 3,000 that they couldn't help me.
Okay, so let me ask you this, and you may or may not know the answer. All right.
Yes, sir.
If you guys paid the 18, I think, well, it doesn't matter. If you paid that amount down to 3,000, then what would happen with Hawk?
She could assist me because the balance wouldn't be so high. She said if it's 3,000.
But they didn't commit to. Jeez.
She didn't even do my application. She just told me that they couldn't help me. I was over the phone.
I'm sorry. I don't mean to laugh. I hear what you're saying. Is apparently somebody has changed the rules. All right. Here's what I do, folks. All right. I'm going to adjourn your case to the 27th, 2024 at 1 p.m. Okay. If you want to wait, you can. I'm going to try not to throw a tirade. Somebody's going to have to explain to me what's going on, because if you guys paid that amount, I'm not sure. You're just supposed to contact them back and they're going to pay. or they're not going to pay.
No, what the lady said that she couldn't talk to me because my amount was over 3,000. She didn't give me no more of. I called SOS and I called Friends Indeed, and they said that their cap is only 500. So I was stuck at that point, and then I did 2 SERs, but I got denied for both of them. So I was stuck at that point, but
The woman shared that her property manager was willing to assist by reaching out to agencies together to better understand why aid was denied and explore other possibilities. She asked the court for more time to resolve the issue. The Judge Simpson, frustrated by the lack of clear support from the agencies, expressed concern over their inability to provide structured plans or actionable steps. They noted that such organizations should assess cases thoroughly and offer guidance, such as partial assistance or strategies to manage outstanding balances.
I was going to go back to my property manager and see if we could figure out something, if she can.
Okay. All right. I'm going to put you over to next week. All right. After I get finished yelling at some people, I'll be able to give you clear instructions about what to do.
Yes, sir.
That's if they pick up my phone call.
Yes, sir.
They probably won't now, but we'll get that clear for you, because right now you guys don't know necessarily what to do.
No, sir. And our property manager is willing to help us, work with us. So I'm just waiting.
No, I get that. And then, and I don't know whether Sycamore Meadows, and they have on some cases, but I don't know what their threshold is, their payment plan for whatever the balance may be. So, and what I'm saying, and this is part that's confusing me, they should have assessed you, done everything for you, said you need to come up with X amount. If you come up with it, we'll help you with the other amount. If you don't, whatever. But sometimes that coming up with the other amount can be a payment plan as to how you're going to pay it and then pay your future rent. Does that make sense to you?
Yes, sir.
And I don't know why that wasn't presented. I'll do my best to figure it out over the holidays. All right. And then we'll see you guys on the 27th. All right. Thank you.
To allow for more time to investigate and provide clarity, the judge granted an adjournment, rescheduling the case for December 27, 2024. They promised to contact a primary organization directly during the holidays to gain insight into its policies and better assist the defendant. In the meantime, the woman planned to collaborate further with her property manager to explore any remaining options and potentially reduce the balance to qualify for help. The case involved Mr. Reggie Lee King, who appeared in court to address charges of assault and battery from an incident in May at the Spartan Motel. According to the complaint, Mr. King had an argument with the victim, Lori Wilkers, during which she felt threatened and claimed she had been pushed and had her hair pulled. The charge was a misdemeanor, carrying a maximum penalty of 93 days in jail and a $500 fine.
Mr. King, you were charged with assault and battery last May for an incident that occurred at the Spartan Motel, and the complaining witness was Lori Wilkers. Lori Wilkes. All right. You spent 8 days in jail, and then you posted a bond, and then you got out. Then you failed to appear again, and you posted another bond. So you spent 18 days in jail so far, and then I think you got arrested yesterday. How did you come to get arrested yesterday?
I have no clue.
Did they come and stop you at the motel or what?
No, I don't live there no more.
Where did you get arrested?
I got arrested at my brother's house.
After the incident, Mr. King was initially arrested and spent 8 days in jail before posting bond. However, he failed to appear for a subsequent court hearing, leading to his second arrest, during which he spent an additional 10 days in custody. He posted bond again and was released, but was later arrested a third time at his brother's residence, bringing his total time spent in jail to 19 days.
Let me cut right to the chase. I don't need to know this part, but you've been in jail for a total of 19 days. 8 days, 10 days, and one more. So I represented to your lawyer, Mr. Knopfinger, that if you plead guilty to assault and battery and knocking that girl down or pushing her down, that I would give you 19 days jail, credit 19 days, and take your fine out of your bond. Now, assault and battery is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500.
No, but see, there's cameras on that too. Just like there was with the other one. With the one that hit me in the head with the baseball bat.
All right, well, this doesn't have anything to do with a baseball bat. She contended you got in an argument with her and you pushed her and pulled her hair back in May 11th. What?
It's not according to what the camera said.
All right, well, okay. So my representation to you and your lawyer is here. If you plead guilty to an assault and battery on Lori Wilkes, I will give you 19 days jail, credit 19 days, and use the bond to pay your fine.
So, Judge, that means that the case would just be over today?
Correct.
And then would Mr. King get out of jail today and he wouldn't owe any fines and costs? You'd take it out of his bond?
Correct.
During the hearing, Mr. King explained the circumstances of his most recent arrest, though the judge redirected him to focus on the charges. The court proposed a resolution where Mr. King would plead guilty to the charge of assault and battery in exchange for credit for the 19 days he had already served in jail. Additionally, the judge ordered that the $200 in fines and fees, which included a $125 crime victim rights fee, a state minimum fee, and a $75 attorney fee, be deducted from his bond.
Mr. Knopfinger, did we resolve the case?
Yes, Judge. Spoken to Mr. King. Also, he's apologetic for the language he had used earlier. He's just a little frustrated. He will enter a plea to assault and battery. The factual basis, Judge, will be in one in which he did approach her and she was under the immediate apprehension of a battery and kind of reacted.
All right. Mr. King, other than what I told you about what I proposed to do for the sentence, did anybody promise you anything to get you to plead to this?
No.
Or threaten you to try to get you to plead?
No.
You understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury. If you had a trial, you'd have the right to be represented by an attorney. And as I indicated, Mr. Knopfinger made a special effort to be here with us this morning.
Yeah,
if you had a trial, you'd have a right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Did you get into some sort of disagreement with this Lori Wilkes back on May 11th?
I got in a disagreement with her and I got up in her face, but she dropped to the ground and she must have thought I hit her.
That's sufficient.
Mr. King's attorney confirmed that his client was prepared to accept the plea agreement. Mr. King admitted to having an argument with the victim, during which she felt threatened, leading to the court accepting his guilty plea. The judge also addressed other financial obligations, choosing to wipe out one of Mr. King's outstanding fines from a previous case to simplify his responsibilities.
Have you got a way to get back to Three Rivers?
I don't think so.
All right, well then you walk up here to the courthouse and the bailiffs will make sure you get a bus pass, okay?
Well, can I get a ride with you?
No, I won't be, whatever direction you're going in, I won't be going in that direction.
That sounds fun. Me and you hanging out in the car?
Yeah, that sounds like great fun. Maybe ride the back of my truck. All right.
Hey, I can we can stop getting a pre-roll.
All right.
Come on, man.
All right. You're pushing the envelope here, Mr. King. I'm going to give you 19 days jail credit, 19 days, a $125 crime victims' rights fee and state minimum fee and a $75 attorney fee. That adds up to $200 from the bond is $200. Now, you've also got you got a bunch of other unpaid stuff. I'm gonna wipe out another one. 23643 FY, felony disturbing, that was reduced to disturbing or attempted R&O or something. I'm gonna wipe that out. There's others, but I'm just gonna deal with that one. All right, Mr. King, you should be able to get out. Hopefully you get lunch. If you need a bus pass, stop at the courthouse. The bailiffs can give you one.
The judge finalized the case by confirming that Mr. King would be released from custody the same day and advised him to visit the courthouse to obtain a bus pass for transportation. The defendant, in turn, offered a pre-roll, which made the judge and attorney laugh. The session ended with the judge encouraging Mr. King to stay out of legal trouble moving forward and expressing hope that this resolution would help him make better choices in the future. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.